Welcome to Road to Recovery.
Hello there, and welcome to Road to Recovery, advocacy and insights for trucking accidents with Sagi Shaked. I'm Kevin Rosenquist. Thanks for being here. Sagi is founder of Shaked Law Personal Injury Lawyers and is ranked as one of the top 100 trial lawyers in the United States by the American Trial Lawyers Association, with a wealth of experience in personal injury, wrongful death, and complex litigation cases. He passionately advocates for victims and has recovered multi-million-dollar settlements in damages for his clients. Sagi, welcome.
Thanks for having me, Kevin.
All right, so today we're going to talk about navigating comparative negligence in trucking accident claims. So tell me, what is comparative negligence and how does it apply specifically to trucking accidents?
It's a good question. Comparative negligence in Florida, well, this is throughout the United States. Comparative negligence means just comparing the fault of the driver of the truck versus, let's say, our client. So you're comparing one person's negligence versus the other. So a lot of times you'll see with juries, they'll allocate some fault on one person or the other, or sometimes, let's say it's a rear ender, they'll allocate all the fault, if it's a trucking accident, on the truck that did the rear ending. So comparative fault means the percentages of fault that they'll put on the driver that's at fault. If there's multiple drivers at fault, so they'll put some on one driver, some on another driver. It just depends on how the crash occurred. So if it's let's say it's a T-bone collision, sort of like a T, where you have one driver saying not me and the other driver saying not me, then it's up to the jury to determine who's at fault and what they believe based on all the evidence. And then they'll put allocations of fault. So comparative fault is just an allocation of fault. How much fault do you put for one party versus the other party? And when I say party, I mean the people driving in a trucking accident.
How does Florida specifically handle comparative negligence in trucking accidents? Might be different from other states.
Yeah, and it completely is. In Florida, comparative negligence is different. Now, it's important to note the time period when the crash occurred. So Florida law recently changed on March 24th of 2023. It used to be prior to that date. So before March 24th of 2023, it would be pure comparative fault, which means it doesn't matter how much fault the plaintiff, the person bringing the lawsuit, has. So if the person bringing the lawsuit is found 60% at fault and the truck driver 40% at fault, the truck driver would still have to pay for his or her 40% at fault. The law changed from pure comparative, which means no matter how much at fault the plaintiff is, the defendant would still have to pay their percentage. So again, we gave that 60-40 example. Now the law changed effective March 24th of 2023, where we moved from comparative negligence to what they call modified contributory negligence or modified comparative negligence, which means this, that if you, the plaintiff, the person bringing the lawsuit, is found to be more than 50% at fault, so it could be 50.01% at fault, you get nothing. So in your traditional, think about like we spoke about before, a T-bone collision where one person collides into another, or it's a he said, she said. If the jury finds that your client, or let's say my client, is more than 50% at fault, even by 0.00001, then you get nothing under the new law that took effect on March 24th, 2023. So it depends when the case occurred. If the accident occurred before March 24th of 2023, then it goes under pure comparative negligence. But if it occurred afterwards, then you're going on that, what they call modified contributory or modified comparative negligence, where if you're found a little bit over 50%, you get nothing. Does that make sense?
Yeah, no, it does. So you're saying, like before in your 60-40 example, if I was 60% responsible and you were 40, we would each be responsible for that percentage?
Correct.
Oh, wow. Okay. So why did it change? Do you know what the impetus for that was?
Yeah. So this goes back like 30 years ago. The insurance companies, they have a huge lobby group. And so what they want to do is keep the money to themselves. They want to keep those premiums that you and I are paying to all the insurance companies and get the laws as much as possible in their favor. So the more money they make, and if they can push these laws, they get the lawmakers to push their agenda. And one of the many things that they passed during that last year's legislative period in 2023 was this bill to change it from comparative negligence to modified contributory negligence. So you have a lot of states that have pure contributory negligence, where if you're found 1% at fault and the other person is 99% at fault, you get nothing. Whereas in Florida, it's not as bad now. It's 50. If you're more than 50% at fault, you get nothing. But there are some other states in the United States that have what they call pure comparative. So even if you are 60% at fault, the defense still has to pay their share of fault. So why did they change it? Insurance companies have a huge lobby group, and they want to ensure that they get as much money as possible from those premiums and have to pay out as little as possible. So this is their agenda. Every year they're attacking on the federal level and on the state level to try to save themselves money and keep, as much of the premiums as possible.
Wow, that's quite a change.
Yeah, it really has impacted a lot of people throughout the state of Florida, because you have a person who's, technically, yeah, they did something wrong, but the other person did something wrong as well, and their life has been completely altered. Now what happens? They could get screwed and get nothing.
So how is fault determined in a trucking accident involving multiple parties?
So the ultimate decision maker, if you can't get to a resolution or a settlement, would be the jury. It could be in some cases you have a bench trial, but I'd say 99.9% of cases go to a jury if they don't get resolved. So most cases do get resolved at some stage. Sometimes it's before a lawsuit, which we know is called pre-suit. And sometimes it's after a lawsuit's filed, that's in litigation. So sometimes they settle before, and then sometimes they settle, at the courthouse steps. And sometimes the jury has to decide fault. So it's up to the lawyer when they're working on these cases to do everything possible from the beginning of the case, throughout the case, to get evidence, preserve evidence, and show what the trucking company did wrong. So as a lawyer, there's just so many things that truck accidents, they're different than car accidents. So you really have to go above and beyond what you would normally do in an auto accident, because there are rules and regulations, statutes that are different than car accident cases that apply to truck drivers. They have a higher standard of care when they're on the road. They're professional drivers.
Sure. I suppose with this new law change, is it fair to say that insurance companies are more willing to give trial a shot rather than settle?
Yeah, you absolutely see that. Since the law changed, you see the offers have been ridiculously low, which means now more cases are going into litigation, which means more cases are now in front of the courts, which means it's harder to get a trial date. We just had yesterday what they call a call of calendar or calendar call, where you bring your case to the court, you have a number, and the judge, this is a 2021 case, and we still can't get to trial. It depends on the judge, but we're now in 2024 and we got pushed to 2025. So you have a case that was filed in 2021. We're only going to get to try that hopefully in January of 2025. So the insurance companies know this, so they get to keep their money, put their money, make it work. They're investing their money, and they have 4 years of investment, so they're making that money back up. In the meantime, my client who's suffering from traumatic brain injury has to continue to wait, and it's frustrating for him and for all the other clients that have to wait to get their day in court or to get justice.
Yeah, that is really frustrating. What factors are considered when allocating fault in trucking accidents? What is the jury looking at?
So the jury is really trying to determine who's at fault. So how do they do that? They look at credibility, and that's really, I think, the biggest key in any case. Do you, as the person bringing the case, have credibility? Does the defendant have credibility? So if what they're saying, sounds like a duck, it walks like a duck, it's probably a duck, right? So if you can show the defendant, driver, or trucking company is lying or trying to pull a fast one, juries aren't stupid. They know what's going on. They're like you and I. They can sense when someone's lying or trying to pull a fast one on them. So if you can prove that, and you can prove it, the way you prove things is, again, getting to the scene early, seeing if there's skid marks on the road, any witnesses, any cameras that recorded the accident, speaking to the witnesses, getting the personnel file for the truck driver, the employment history for the truck driver, finding out, was the truck driver drunk at the time? Was the truck driver using narcotics at the time? Did the trucking company actually test the driver within 24 hours? Now, they should be doing it right away. The driver needs to get tested because they know that crashes do occur when the truck drivers are, obviously you're under the influence of a narcotic or alcohol. That's a big no-no. One, it's against the law, and juries hate that. They don't want to be on the road when someone who's drunk or someone who's, disabled because they're on a narcotic. It's not fair to any one of us that are on the road when you have an 80,000-pound vehicle, barreling down the road and the guy is, under the influence of something. Or they could have sleep apnea. You see that a lot with truck drivers. Again, not all truck drivers, but it's a huge segment of the population that's having these issues. And, like I think we talked about in one of our podcasts, that there's over 4,000 people a year that die from truck accident cases. So this is a real problem that needs to be addressed. And the Federal Motor Carrier Safety Administration tries to address it by putting these laws together. Congress passes the laws and they have to administer those laws and regulate them. So we hope that, by doing that, they can make the roads safer. But we know that if you're a trucking lawyer, you know those regulations and you know what questions to ask, because most of the time when these truck drivers are involved in crashes, they're not following the rules and regulations. So we bring that up to the jury. Let the jury decide, hey, they're not following the law. This is inevitable. You can't just, stick your head in the sand and hopefully everything will go well with the jury. A good lawyer that knows what they're doing and has had experience and tried cases, trucking cases, will bring about all those violations of the law. And that's one way to do it, right? So we talked about witnesses, we talked about video, we talked about violation of the rules. That'll help show who's at fault in the crash.
How does comparative negligence affect the compensation that you receive?
So comparative negligence has a huge effect on compensation. So we're going to put aside the injuries for a second, but when you talk about if your client is, as let's say I'm the lawyer representing someone, if my client's 50% at fault, whatever the normal value for that case is going to get cut by 50%. And that's what insurance companies do all the time. So let's use a typical rear end collision where the client is sitting at a red light and gets smashed by an 18-wheeler. There shouldn't be any comparative fault on the person that is sitting at the red light. So that would be easier. But then when we go back to that like T-bone collision case where it's he said, she said, the insurance companies, unless you can prove that your client, the plaintiff is always the one bringing the lawsuit, unless you can prove your client had the green light and had the right of way, they're going to allocate some fault, what we call comparative fault or comparative negligence, onto your client. And they're going to say, we're going to put 25%, 30%, or whatever they believe is, whatever the insurance company believes is the number they want to put. Now, sometimes they put way too much fault on your client and you have to prove that it's not that much. And you go in front of a jury and then you prove it. The question is, how long does it take to get to a jury? Insurance companies know it takes forever, sometimes 2-3 years before you can get in front of a jury, and your client has to wait years with those injuries before they get justice. So it's really up to the jury, but it's the lawyer who's got to really bring forth the evidence and show them why your case is more credible than the defense's case over there.
Well, that's interesting because it's tough because, if I have the right of way, if the light turns green and I start driving and someone hits me, it's hard to prove unless there's some sort of camera or witnesses. It's really hard to prove that the light was officially green, right?
Well, yeah, you would hope someone would step up and be a witness because it happens. But sometimes we can get the sequencing of the lights.
Oh, wow. Okay.
Yes, you can get the sequencing. We had a case recently where a client contacted us. Her teenage son was involved in an accident with a truck. But when we got the video and the sequencing, it looked like the teenage son was the one that ran the red light. And then we had to unfortunately tell them that, we're sorry, we can't help you in that case because the sequencing and the video clearly showed that he was in the wrong and the truck driver in that case was not in the wrong. So there are cases where the truck drivers are not in the wrong.
Sure.
And that was one of them. It happens. I mean, like I said, not all of them are bad. Just, it's like everything. There's always a segment of the population that's bad and not complying with the laws and causing people to unfortunately get really hurt.
How do you prove the degree of fault? You mentioned that, sometimes if you feel like the insurance company is coming out and saying that there's too much fault on your client, then it's up to you to prove otherwise. Like, how do you do that?
So a lot of it is with hopefully witness testimony or the testimony of the two drivers. If it's two drivers, sometimes it's three, but taking that truck driver's deposition. So If you're taking a truck driver's deposition, what I would say is number one, all depositions need to be videotaped, because a lot of times when someone's talking, so for those of us who are listening to the podcast and not watching it, you can't see my facial expressions. You can't see my body language. Body language, sometimes when someone's giving you an answer, is completely off to what the answer is. Or
I don't know what you're talking about, Sagi. I don't know.
yeah, exactly. Sometimes you get the smirks to questions that don't deserve a smirk. If
Sure.
someone died in a crash, why are you laughing, right?
Mhm.
Or if if you caused the crash, what's your body language indicating? Is it consistent with what you're saying? That's why I say to any lawyer who's watching this, make sure you videotape every single deposition. It's only to your favor. Now, obviously, if your client's given a deposition, you want to prepare your client for that deposition because it's going to be videotaped by the defense. They're hearing this podcast as well. So videotape every deposition. That's one way where you can show how the driver, the defendant, the person that caused the accident, is at fault or more at fault than your client. Obviously, speaking to witnesses, video cameras, pictures, videos, the credibility of, again, the witnesses. If you have a driver that's not credible, that's violating all types of, federal regulations that talk about truck driver safety, and they're not following any of that, people are going to get pissed. Nobody wants to be on the road with a truck driver that's not following the laws, because that makes a difference and it puts their safety at risk, right? You don't want to be put at risk when you're on the road, you're on the 95 or you're on a major highway. You want to be safe and you want everyone else to be safe because you're relying on everybody following the rules of the road, right? We all have rules. You follow the rules. So if someone's not following the rules, we're going to expose them. We're going to bring it and we're going to show it. So when we go to trial or when we're going to mediation, we show the insurance company, look what they did. Here's why they didn't follow the rules. And then let's say you're in trial and the person says something different, right? And you're trying to prove fault. And now in trial, their story completely changes. I'm going to ask them if they've ever said anything differently. And if they lie and said they haven't, I'm going to expose them and show them, hey, wait a minute. When you were under oath a year ago with your lawyer there, you raised your hand, you swore to tell the truth, and you told the truth, but you told us something completely different. Today in trial, you're changing that testimony completely. So you make them look like liars if they're going to try to get away with one. So our job is to find out what really happened and then expose them if they try to lie. So expose them if they didn't follow the safety laws in place to protect the motoring public, which is you and I and everyone else on the road. So that's one way to do it, where you can show that they're more at fault than the other driver, than your client, is again, locking them down in that videotape deposition. Mm-hmm. So we can see body language, we can see the smirks they're making, we can see the facial expressions, and then having them, locked down, making sure they followed all those safety rules. Because in reality, if they follow the safety rules and they're not on the cell phone, getting distracted while they're driving, an 80,000 pound truck, people won't get injured. Crashes don't occur. But it's the distractions, it's the sleep apnea, it's the being under the influence that causes, life changes to people's lives.
I think that the lawyers in Law and Order need to listen to this podcast all the time. People are changing their stories and they're like, what? Like apparently they're not recording anything in Law and Order.
In Law and Order, some of it is real and then a lot of it is not, because it is entertainment and it's in, the movie business. So sometimes the law, in trial can be a little bit mundane and boring during certain parts of the trial. But, as long as you're prepared and you know your case and you videotape your deposition, you line up every statement that you're asking at trial with that video clip. So if they say something different, you expose them. And we had one trial where the jury didn't believe anything the defense said because the truck driver had 6 inconsistencies about what happened in that case. And every single time I played the video, every time he said something different. And, we had the IT team there. And every time he went to say something different, I'm like, at some point I was like, are you sure you want me to play that video? He's like, no, I agree. I made a mistake. I'm
Sure.
talking about a major issue in the case,
right?
Not picking on little details. Nobody wants to be, crucified over a little detail. But if you're saying the light was red and suddenly in trial, you're saying you had a green light and completely fabricating it, we're going to expose it. That's our job, to represent someone and ensure that they get max compensation by getting the truth out there.
Absolutely. Well, Thanks for tuning in to Road to Recovery, Advocacy and Insights for Trucking Accidents with Sagi Shaked. For more information or to connect with Sagi, visit shakedlaw.com. That's SHAKED law.com. And don't forget to like and subscribe. Sagi, great to see you again. Thanks for being here.
Thanks for having me, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.